Sat Shri Akal. Public trust in judiciary has to be earned and it cannot be commanded. Parting words of the outgoing Chief Justice of India, Honorable Mr. Sanjiv Khanna. He was the 51st Chief Justice of India, sworn in November 2024. He is the chip of the old block. His father, Honorable Mr. D.R. Khanna, was judge of the Delhi High Court. His uncle, none other than Honorable Mr. H.R. Khanna, was the judge who gave the lone dissenting judgment in the ADM Jabalpur case, upholding the right to life and personal liberty of the people in the dark days of emergency, knowingly sacrificing the Chief Justiceship of India. As curtains draw on the tenure of Cji Khanna in the Supreme Court, here are his key initiatives, judgments and orders which throw light on his short but impactful tenure. His prompt action about the burning cash found in the house of Justice Yashwant Verma, the Delhi High Court judge, by asking him to resign, and on his refusal to resign, putting the report to the President of India, shows his integrity and honesty towards the institution. In an historic and significant step, he made mandatory that the Supreme Court judges should make their assets public, which can be found on the site of the Supreme Court. Along with that, he made public the collegium recommendations that were made from November 2022 to May 2025. Again, putting forward his trust towards the institution and making it more transparent. He impressed upon the need to improve the art of drafting to keep the petitions short and crisp. While dismissing the Vishal Tiwari versus Union of India petition, his bench observed, and I quote, "Any attempt to cause alienation or humiliation of the targeted group is a criminal offence and must be dealt with iron hand." Again putting forward his constitutional ideals. While emphasizing on the importance of mediation, he said that it is not a lesser form of justice but a wiser form of justice because it achieves the role of social justice which is inscribed in the preamble to the Constitution of India. While hearing the petitions referring to the Places of Worship Act 1991, Justice Khanna rightly passed the order that the status quo of the mosques to be maintained, but missed the opportunity to do away with the real mischief, that is the order passed by his predecessor CJI D.Y. Chandrachud, in which CJI D.Y. Chandrachud allowed the survey of the places to determine their character. Though Justice Khanna's order did halted the flow of the petitions, but it did not close the doors for any future mischiefs. To an extent, he tried to protect the social fabric of the country. While hearing the petitions challenging the Waqf Amendment Act 2025, his bench did an elaborate hearing and raised some concerns about the amendments, which included Waqf by user and inclusion of non-Muslim in Central Waqf Council and the State Waqf Boards. The matter is still sub judice. It must be noted that when Union argued that if non-Muslims are not accepted in the Waqf councils, then a non-Muslim judge also cannot hear such cases, to which Cji Khanna evocatively said, "When we sit here, we lose our religion, we are secular." Again, showing his commitment towards a secular institution. Passing the judgment in Radhika Agarwal versus Union of India, his bench upheld the right to life and personal liberty of the people by upholding that the arrest provisions in these acts are justified, but there is a higher threshold on the police officers to show that they have a reason to believe before arresting the accused. While dismissing a plea challenging insertion of the term secular and socialist in the preamble, his bench observed that Constitution's preamble in its original form itself reflected secular ethos even before the passing of the 42nd Amendment 1976, which inserted these words. The only Constitution bench judgment during his tenure, the Gayatri Balaswamy versus ISG Nova Soft Tech Limited, in which It was held that the courts have the power to modify the arbitral awards passed under Section 34 of the Arbitration Act, and the Supreme Court also holds the power under Article 142 to modify these awards, but the power to be used with care and caution. He also motivated young lawyers to give back to the society by doing pro bono and legal aid work. He made a mark in the administration as well. When he sworn in as a Chief Justice of India, he raised the concern about the backlog of the cases, to which he took some important steps. He streamlined the process of mentioning urgent fresh matters by moving it online, giving a sigh of relief to the lawyers. His one big move towards the disposal of the cases was to direct that regular matters, that is the cases already admitted for hearing, to be heard on regular basis rather than twice a week, which was the earlier practice. This led to a disposal of the registered cases to almost double the cases instituted. That is 19,291 cases disposed, over 10,653 were instituted. Disposal rate increased by 30%, again making a mark in the administration as well. The brief tenure from 11th November 2024 till 13th May 2025 has added to his ongoing legacy of a great judgeship. He is indeed a great judge and a great man, as said by his predecessor, Honorable Mr. H.R. Khanna.